So the first lecture is about what is the law of naval warfare? What makes it so special? Of course, we know it applies at sea, but it's not only the respective environment which makes it so special. You have to understand that the law of naval warfare consists of three pillars. Three. The first, many of you are familiar with. The rules of international law regulating the conduct of hostilities and the protection of victims. Many of you are familiar with that from the land warfare context and so on and so forth. However, since we are at sea, warships cannot endure forever unless they are nuclear powered. So they may have to call in a port of a neutral country. And therefore, the law of maritime neutrality is also very important. And last but not least, the third column or pillar is prize law. Many people said, prize law, what is that? And if you Google it, you will find all kinds of entries, but they have nothing to do with what we are talking about here. It is, if you so wish, a remnant of economic warfare at sea. It means that the belligerents are entitled to capture vessels and eventually to confiscate the vessel and the cargo. This certainly applies to enemy merchant vessels, but under certain conditions, it also applies to neutral merchant vessels. You may remember yesterday we talked about the impact of armed conflict on sea trade. Well, in armed conflict, this interference with sea trade is rather the rule than the exception. Many people keep forgetting that. Now, what does that mean for you? The conduct of hostilities rules, of course, they apply between the belligerents, between the parties to the conflict. And the same holds true for the relation between a belligerent and even neutral vessels or aircraft. Why? Because neutral and aircraft and vessels may, by their conduct, become lawful targets. So you may sink a neutral merchant vessel if it does certain things. We will return to that the day after tomorrow when we talk about targeting. So that's very important to keep in mind. Protection of victims. We have an entire Geneva Convention number 2 of 1949 dealing with the protection of victims at sea. However, if you look at the list of protected persons under the Second Geneva Convention, you will see all kinds of categories of persons. Crews of enemy merchant vessels, those accompanying the armed forces, war correspondents, and so on, who are protected persons under the Second Geneva Convention and who are also protected under the Third Convention because they would enjoy prisoner of war status if they fall into the hands of the enemy. However, since I just mentioned, you may sink a neutral merchant vessel, right, if certain conditions have been met. What about them? Are they protected victims? According to the black letter rules of the Second Geneva Convention, no, you don't find them there. Why? Because the mandate of the conference was limited. They were not allowed to even think about neutrality, certainly not about neutral merchant vessels, even though in 1949, when the conference took place, they did, of course, know that neutral merchant vessels may become lawful targets, but it's simply not part of their mandate. Maritime neutrality. And here, please, we will talk about maritime neutrality. Pete Pedroso will give a lecture on Saturday, but please keep one thing in mind. Neutrality is about the relations between states only, meaning the belligerents and a neutral state. We can now talk about qualified benevolent neutrality. Just leave it aside for the time being. What is important? It's about protecting neutral states, in particular their territorial sovereignty and integrity, from the effects of the war, and at the same time, subjecting the neutral states to certain obligations, in particular impartiality vis-à-vis both belligerents. So neutrality has nothing to do with neutral merchant vessels. Okay? Neutral merchant vessels are covered either by the rules on the conduct of hostilities or by prize law. Has nothing to do with neutrality. Please don't forget that. Finally, prize law. This certainly applies between the belligerents. All enemy merchant vessels are liable to be captured during the entire duration of the conflict, only because they are enemy. And neutral merchant vessels may also be captured, at least visited and searched, and even captured if certain conditions have been met. So the same applies, by the way, to civil aircraft that are liable to be captured. We will talk about that extensively on Saturday, but please keep those three pillars of the law of naval warfare in mind. This is why the law of naval warfare is quite different from land warfare, which you may be familiar with. Prize law. You will talk about that in lecture 9, right? And here we go back already again to 1856. 1856, the first treaty prior to the 1864 Red Cross Convention. The ICRC keeps forgetting that. The first multilateral treaty dealing with the law of armed conflict is the Paris Declaration. And there you find some rudimentary rules on prize law. So, if you have an enemy vessel, then the primary rule is it's liable to be captured. In the next lecture, I will talk about which vessel is enemy, which vessel is neutral. But that is something you have to keep in mind. There are some specially protected enemy vessels, and I think Rob McLaughlin will talk about them. But this is not what I have to deal with here. With regard to neutral merchant vessels, they are not liable to be captured unless they do something. For example, carrying contraband, meaning goods destined to the enemy that are prohibited by a contraband list issued by one of the belligerents. And don't forget, if you want to apply prize measures, every prize must be adjudicated upon. So if the Philippines wants to capture Chinese merchant vessels, you have to have a prize court. You can assign that task to a standing court. Okay, you don't need to establish a court only for that purpose. You can assign the task to an existing court, but please don't forget that. Maritime neutrality, we have only one convention which dates back to 1907, Hague Convention 13. And there you find many rules on the obligations of neutral states in the maritime context. There is another one, Hague Convention number 5, on neutrality in land warfare. All right? But belligerents are obliged to respect the neutral status of those countries, and at the same time, the neutral state is subjected to the obligation of treating both belligerents impartially. No discrimination. The practical relevance of that law, many people say, this is outdated. No, it's not. The best example of how relevant it can be is the Graf Spee incident of Uruguay in the Second World War, where the Brits played the card of maritime neutrality brilliantly. So you see, it still has relevance, and it can even have a strategic impact on the ongoing armed conflict. Now, those of you who attended yesterday or the last 2 days' conference may recall that the law of naval warfare is primarily designed to apply in international armed conflicts, in armed conflicts between 2 or more states. Primarily, we have to go into every detail of the elements that must be fulfilled for an armed conflict, for an international armed conflict to come into existence. And you may recall that I talked extensively about the one-shot rule. Does the law of naval warfare in its entirety apply as soon as one shot has been fired? My view is that is not the case, because it doesn't make sense. Of course, the rules protecting victims, they will be applicable. Second Geneva Convention and so on and so forth. But not necessarily all rules of naval warfare, such as prize law, automatically become applicable only because someone has pulled the trigger. So we must be very clear on that. Some try to deal with unclear situations, such as incidents at sea or in the air, by establishing or by claiming that there needs to be a belligerent nexus. I never understood belligerent nexus. The DPH study also uses the belligerent nexus approach. I don't know what that means. I just look at the facts. So if there is a use of force by one state against another, this is for me enough. And I don't need any subjective or other kinds of elements for an international armed conflict to come into existence. I cannot read the mind of the enemy. Or do I have to ask a psychiatrist to talk to the enemy and ask him, what were your underlying intentions, etc.? I mean, this is impossible. So we have to look at the objective picture. Is there a use of force? Yes. Is that use of force attributable to a given state? Yes. Is the use of force directed against another state? Yes. What do you have? An international armed conflict. Don't forget, we are not necessarily talking about situations that extend over months or over years. An international armed conflict can be of a rather short duration, which has been determined, for example, by the prosecutor's office of the International Criminal Court and by the ICRC, by the way, in the incident between the two Korean states where North Korea sank a South Korean fast patrol boat. That was more or less it, and then the conflict was over. Nevertheless, during that time, we have to apply the rules of naval warfare. Now, in non-international armed conflicts, many people said law of naval warfare does not apply to non-international armed conflicts. Well, that's not true. Remember, Sri Lanka, to give but one example, where the Tamil Tigers attacked ships outside the territorial sea. Is that in a legal vacuum? Of course not. Of course not. So therefore, we have to always very carefully look at the two parties of a non-international armed conflict and to distinguish between the state party to that conflict and the non-state party to that conflict. And the state party is, of course, a state, right? It enjoys all the rights international law provides for. So if the state party wishes to take measures against foreign ships, this is not the law of naval warfare. Okay, prize law does not apply in a non-international armed conflict. The law of maritime neutrality does, in principle, not apply in a non-international armed conflict unless, a theoretical issue, there is a recognition of belligerency. Okay? It occurs once in a while, maybe not explicitly, but implicitly, but usually in a non-international armed conflict, only the rules on conduct of hostilities and on the protection of victims apply. Now, if the non-state party to that armed conflict takes measures against foreign vessels, not the government vessels or those affiliated with the government, and if they do it outside the territorial sea, well, I would argue they are pirates, if the two ships criterion is fulfilled, of course. But don't forget, piracy also includes aircraft. So it's not only two ships, but it could be an aircraft against a ship. Remember, the Houthis boarded foreign vessels in the Red Sea from the air and took control over them. For me, that would qualify as an act of piracy. Private ends, there are different interpretations, but I think the prevailing view will soon be that private ends is not the opposite of political ends, but the opposite of governmental ends. And then you get it. So please keep that in mind, because many people tend to either forget the law of naval warfare altogether, or they confuse things. They introduce neutrality, for example, and concepts like these, they don't apply in a non-international armed conflict, which means that the state party to a non-international armed conflict cannot say, now we are exercising price measures far outside the territorial sea. There were examples, Algerian crisis, where France did it, but that met heavy protests by all states affected. It's a little bit different with the armed conflict between Hamas and Israel, because according to the Palmer report, that is a non-international armed conflict, but it's so special that it's closer to an international armed conflict than any other one. And we could now enter into a long debate without a result. Is Palestine a state, yes or no? Would the law of naval warfare apply in total, etc., etc.? I don't want to go into that. I don't want to go into politics, by the way, all right? Because we will never arrive at a consensus. This is not a political seminar, it's a naval warfare, law of naval warfare academy. So it's a legal thing. It's not a political thing. Any questions so far? Well, we will see in the afternoon. Huh? Are you certain? Very good. All right. Now, remember, the treaties dealing with law of naval warfare, at least in parts, are very old, very old. The first one, 1856, Paris Declaration. Then comes the second Hague Peace Conference of 1907, where 5 conventions were adopted that only deal with the law of naval warfare. 5. It was a peace conference, by the way. And what did they do? They adopted rules on conduct of hostilities and so on and so forth, far from being a peace conference, which is quite an interesting development. Then, after the First World War, we have the London Submarine Protocol, a very important document because it contains some basic but very important rules that are not limited to submarine warfare, but submarine warfare triggered the adoption of the 1936 protocol. Of course, Geneva Convention 2, I already mentioned it, important treaty, no doubt about it. And later on, nothing. Nothing. No modern treaty on the law of, or no modern treaty specifically dealing with the law of naval warfare. Now, this begs the question, well, what about the modern codifications, right? What about additional Protocol 1 and all this? Well, first of all, don't forget we have manuals, okay? And we don't only have the San Remo manual and the Newport Manual, but they're also national manuals that you can easily find on the Stockton website, where you have a compilation of national manuals. So consult them. And check what states agree with or what they don't agree with. Pretty interesting. Now, before we come to the additional protocol, what about the law of the sea? Well, for the purposes of the law of maritime neutrality, this is very important, because we know that the law of the sea is inter alia, divides the oceans into certain zones with changing jurisdictional and sovereign rights of the respective coastal state. And of course, when it comes to the question where the law of maritime neutrality applies, we need to check. Is it the territorial sea of a neutral state? Is that territorial sea in accordance with UNCLOS rules, meaning no excessive claims, not extending beyond 12 nautical miles, and so on and so forth. But we have new sea areas that were introduced by UNCLOS, just to mention, since we are in the Philippines, archipelagic waters that didn't exist before. And so we have to then look very closely into it, but we will have a specific lecture on the region of applicability of the law of naval warfare. So please be patient, you will be instructed then. So now additional protocol 1. First of all, you have to understand that the delegates of the diplomatic conference that took place from 1974 till 1977, only 3 years, quite good. But it was, of course, a fortunate time. Remember, the Vietnam ended in 74, and they had overcome some other controversies, so they eventually were willing to come together to adopt new rules on the law of armed conflict, which is the additional protocol. There are two, but we are here only concerned with one, Protocol 1. It is a reaffirmation, but also progressive development of what is called international humanitarian law. I would be a little bit cautious not to misunderstand the additional protocol, because the additional protocol 1 is not only about the protection of victims. It's also about the conduct of hostilities. Okay, far from being humanitarian. Okay, it's about killing people. So be a little bit careful. But of course, the primary focus of additional protocol 1 is the protection of civilians and of civilian objects in times of international armed conflicts. Now, if we just have some of the states bound by the additional protocol 1, who are the states that are represented here, I mean, yeah, which state is missing? Loud? The United States of America. Right. Lucky them. Lucky them. Well, there were all kinds of reasons why President Reagan in those days decided not to ratify the protocol for a variety of reasons, which I don't go into now. But you see, most of the states of the world are parties to the additional protocol 1. And despite of the fact that the mandate of the conference was not to include the law of naval warfare, they said something about the law of naval warfare. Now, the core provision in that regard is Article 49, paragraph 3. And let's start with the second sentence. First of all, you have to read it carefully, very carefully. It's not about the applicability of the additional protocol 1 in its entirety. It only applies to the articles 48 to 67, which may not apply when there is a maritime or naval element. All right? And the second sentence does something which was clearly within the mandate of the conference. Attacks from the sea against targets on land are regulated by the entire protocol, including articles 48 to 67. Those are important articles. 48, principle of distinction. 52, definition of military objectives. 51, prohibition of indiscriminate attacks. 57, precautions in attack. So all these rules apply if you attack targets on land from the sea. That is, I think, only logical, because it's about protecting civilians, right? And protecting civilian objects on land. Now, the funny thing is that this is only laid down in the second sentence. But if you look now at the first sentence, this is becoming a little bit strange. So obviously, it's only about Articles 48 to 67. Secondly, land or sea warfare, which may affect the civilian population, civilians or civilian objects on land. So it's not the situation where you attack targets on land from the sea. That is the second sentence. There we are on safe grounds. The entire protocol applies. But can you imagine armed conflict at sea which may affect the civilian population or the civilian objects on land? What are we talking about? I think that was coming close to the borders of their mandate, because I don't know what they really had in mind, but someone must have said, yeah, but what if a naval engagement occurs near the coast? And then the effects may impact the civilian population or civilian objects on land. This is, however, when we focus on conventional naval warfare, rather rare. But for those states that are party to Additional Protocol 1, they have to keep that in mind, because the legality of their measures will be measured by Articles 48 to 67. You cannot just ignore that. So you must be very clear what kind of sea warfare you are talking about. Now, if we have solved that problem, distinguishing between the first and the second sentence of Article 49, paragraph 3, then we read further in the protocol, and then we arrive at 57. 57 is about precautions in attack. And when it comes to attacks against targets on land, those who decide or plan an attack must take all feasible precautions to ensure that their attack is directed against a lawful target, that the civilian population is spared as much as possible. I won't go into that because we will talk about that in the context of targeting. But now suddenly, the standard that is introduced by the fourth paragraph of Article 57 is not feasible. It's reasonable. Feasibility has been defined as everything practical or practically possible in the circumstances ruling at the time, by also including considerations of humanity and military necessity. So it's pretty clearly defined, although it leaves some questions. But what does the standard of reasonableness then mean? Make up your mind. It cannot be the same, because if Article 57 distinguishes between feasible and reasonable precautions, there must be a difference. And please don't say, it doesn't matter. You would be a bad lawyer. Okay? If a treaty uses different concepts, they cannot mean the same. So this is already a difficulty for states party to Additional Protocol 1 when it comes to naval warfare. So I think the best way of defining the scope of applicability of the Protocol 1 is when it's sea to sea, you have a target, let's say in the middle of the ocean, okay, and you are firing at the target. This is not governed by Articles 48 to 67. There can be no impact on the civilian population on land, and certainly the attack is not directed against targets on land. The same with air to sea, sea to air, and air to air. All right? So there, Articles 48 to 67 do not apply. And remember, the provisions affected by that exclusion via Article 49, paragraph 3, they are pretty important. Pretty important. So in principle, and if lawyers say in principle, It doesn't mean always. Okay, there are exceptions. Be careful here. In principle, we cannot apply, for example, the definition of military objectives in Article 52, paragraph 2. So is there a special rule under the law of naval warfare telling us which ships qualify as lawful targets? And guess what? Yes. Yes. Even if we consider Article 52, paragraph 2 to be reflective of customary law, that does not mean that there may not be additional rules of the law of naval warfare which help you identify a lawful target. I'll give you one example. 52.2 says a military objective is every object that by nature, location, purpose, or use makes an effective contribution to the enemy's military action and the destruction of which offers a definite military advantage. That is the definition of 52.2. Pretty clear. But if you now look at the London Protocol, remember 1936, you will find that a merchant vessel which does not comply with belligerent orders, or if it renders active resistance without engaging in hostilities, but just trying to escape, is a lawful target. So this does not really fit with a general definition under Article 52. So another reason why the law of naval warfare is quite special. And we will hear about other lawful targets later on. So this is a very important thing you have to keep in mind. So if we deal with states party, with the exception of those that are not states party to the additional Protocol 1, it is quite clear. The entire protocol applies when it comes to attacks from the sea against targets on land. If they can have an impact, well, then a different precautionary standard applies, but nevertheless the other rules do apply. Definition of military objective, prohibition of indiscriminate attacks, and precautions in attack, however, with a different standard, reasonableness, as distinguished from feasibility. Now, let's stay with sea-to-sea, air-to-sea, etc. Engagements. Do they occur in a legal vacuum? No. Because remember, we do not only have treaty rules, we also have a lot of customary law. A lot. Okay, because there is no specific codification after 1949. And if you look at the manuals, the Newport Manual that all of you should have available now, and of course, even the Sanremo Manual. SRM stands for Sanremo Manual, NM stands for Newport Manual. There are a couple of differences between the two manuals, but all agree that the principle of distinction as a customary principle of the law of armed conflict applies. So in other words, you must always distinguish between lawful targets on the one hand and protected objects on the other hand. I'm not including here individuals. Why? Because the law of naval warfare is primarily concerned with objects. We want to sink ships, okay? We are not so much concerned about individuals. Therefore, we can agree on that. However, I've already mentioned the impact of the Submarine Protocol, extending the classes of lawful targets when it comes to vessels. And there is also another thing you have to keep in mind. Over the decades, prior to the adoption of Additional Protocol 1 and after, the US, for example, has always maintained that an object that makes an effective contribution to the enemy's war-sustaining effort would also qualify as a lawful target. What do they mean by war-sustaining? Well, of course, they are referring to the war of aggression of the North against the South, meaning the American Civil War. what happened there, the cotton fields of the South were burned or set on fire. Why? Because that was the main source of revenues for the South. Without selling cotton, no money, guess what will happen? And that war-sustaining approach is not shared globally, to be quite clear. On the other hand, and that's important, it's not a unique position of the United States either, because their manual, the NWP 1-14 Mike, last edition just 2 years ago, that has been adopted by other states, both in this part of the world and in South America. So we really have to be careful to say, or not to say, it's a typical American thing. That would be too easy. And make up your mind, okay? I personally am rather with effective contribution to the enemy's military action than with the war-sustaining effort, but make up your mind. So, as regards the other provisions that are excluded by the Additional Protocol 1, again, indiscriminate attacks, yes, they are. That applies also as customary law in the naval context. However, this is rather theoretical. I cannot really imagine naval warfare, meaning only at sea or in the airspace above, no effect on the civilian population, where you could have an indiscriminate attack. There is something which comes close to it. This is unrestricted warfare at sea. For example, sinking every merchant vessel destined to England. Is that indiscriminate, or is it just a violation of the law of naval warfare by sinking ships that do not qualify as lawful targets? The Germans did it, the Americans did it, the Brits did it in the Second World War. We even have a judgment, I will come to that, of the International Military Tribunal. So, this is important here. So, I still have 5 minutes, so I will keep in time. Submarine Protocol, very important. You see here you have that exception, or this additional criterion for a merchant vessel becoming a lawful target. So any merchant vessel persistently refusing to stop while being summoned or rendering active resistance is a lawful target. At the same time, the protocol is relevant for prize law, because under prize law, if you cannot capture a vessel at sea, too difficult, you don't have enough personnel, etc., then you may exceptionally sink it, even though it does not qualify as a lawful target, but you must first take passengers, crews, and the ship's documents to a place of safety. Then only can you sink it. So it has nothing to do with targeting. It's only prize law. But on the other hand, what is here in bold tells you, if it is rendering active resistance, the ship is not protected by the protocol. Then you can sink it without first taking passengers, crew, etc., to a place of safety. So, if a merchant vessel, however, is a lawful target, then what can you do? Sink it without prior warning. And that is important because the Dönitz judgment, the International Military Tribunal in Nuremberg, dealing with major German war criminals, one of the accused was the German Admiral Dönitz. And he got away with only 10 years. Only 10 years. Even though he was accused as a major criminal. Why? First of all, he was accused of unrestricted submarine warfare. But the tribunal hesitated to convict him for that. Why? Because the US Admiral Nimitz testified in favor of the German admiral and said, we did exactly the same in the Pacific. Every merchant vessel destined to Japan, when we could, we sank it. So the court was in a uncomfortable situation. Had it said Dönitz was a war criminal, it would have implicitly said Nimitz was a war criminal as well. And the Brits had done the same, by the way, in the Skagerrak. Okay. However, another important clarification in the Dönitz judgment is that British merchant vessels that were armed or that were integrated into the British warning system, or that were traveling under an order to ram a German submarine when the German submarine tried to visit and search it. The court said those British merchant vessels were all lawful targets. So be careful arming a merchant vessel. Okay? It's not prohibited, but the vessel may become a lawful target for that very mere fact. So finally, what about attacks from land against vessels at sea? Sounds like land warfare. It's not. It's naval warfare. Okay, because the Law of Naval Warfare will tell you which ships are liable to be attacked or otherwise being treated. So that's important to keep in mind. Just some final words. Last slide. Oh, I'm good. So the rules are old, very old. Many of those rules rely on visual identification. No, in the good old day, they had binoculars, if at all, and they could identify the vessel, and then the commander ordered the attack. Those days are gone, okay? Gone for a long time. We are operating here, when we are fighting at sea, in a very technologically and electronically characterized environment. Rarely will you see with your eyes what you are firing at. Okay, it's no longer visual identification. And therefore, many of the good old rules, which we are so fond of, you may have to adapt them at least to the modern circumstances. I give you but one example. In the good old times, we said ruses of war in naval warfare are permissible. One of the ruses would be you disguise your warship. You make it look like an innocent merchant vessel. Some Germans were pretty good in that. Okay, Count Luckner. He sank some British ships, also in this region. But the rule said, prior to the attack, you have to show the enemy who you are. In the good old days, they just did it by just showing their flag, and then the enemy, oops, too late. Okay? That was a permissible ruse of war. But the question is, how do you do it today? So would a warship, for example, be allowed to have an AIS system on board, identifying it as a merchant vessel, a neutral merchant vessel, and only prior to the attack, and the target is, let's say, 50 miles away, would they then have to say, sorry, we are, and then you fire the missile? Difficult. So yes, it's always romantic to look at the good stories of the past, but please keep in mind the electronic and technological environment we are operating in, and this develops on a daily basis. All right? We cannot just apply those rules of the past one-to-one to the situation today.